EEOC just yesterday came out and updated they've got a question and answer document on their website that they've been updating pretty regularly. And they added a bunch of new questions and answers that provide guidance on how employers can interact with ADA and discrimination and issues with respect to COVID-19. One question that I thought a really good one is, what if an employee doesn't need an accommodation for themselves, but they have a family member that they live with who's maybe older or has some underlying medical condition? Does the ADA require that the employer accommodate that? And the EEOC says no. What this relates to is there's something called associational discrimination. So you know that you can't discriminate against someone based off a protected category, but you also can't discriminate against them because they're associated with someone who has that category, such as they have a family member who has a medical condition. But the EEOC says that doesn't mean that you have to offer a reasonable accommodation based off the fact that somebody has an association with a family member. And it's specifically the employee has to have the protected category to get the accommodation. They had two questions about harassment. One was, how do employers respond if there's harassment against employees who are perceived to be Asian? And then what about harassment specific to teleworkers if there's harassment over email? The EEOC clarified that, harassment is harassment, whether it occurs at the work site or over like email, Skype, things like that. There is no difference. You treat any kind of harassment claim or harassment the same. You want to make sure that managers are trained on their legal obligations so that they can identify and respond to issues early, including who to report to and what they're supposed to do. Keep in mind that you're potentially responsible not just for harassment by your employees, but if your employees are harassed by contractors or customers, that also creates obligations that you may have. I think the most common or the most timely one that you think now of is customers who don't want to have or be serviced by an employee who's Asian related to some fear about COVID-19. You want to watch out for that you don't allow that to be unlawful harassment against your employees. And I'm glad that the EEOC put this in. I'm a big fan of every once in a while a reminder out to your workforce about your harassment policy, informing them of who they can report to and reminding them that you take it seriously. It's really helpful in cases where this kind of, I know you may have it in your handbook, but if you send out an email, it can really, if an employee later makes a claim, it kind of really undercuts their claim to the extent that you sent this email and then they never responded to it. So big fan of sending out occasionally emails to all your workers, reminding them about the harassment policy and what they can do. There was also a question about what are the best practices for informing your employees of the ability to get a reasonable accommodation as they're coming back to work. And the EEOC said there's kind of two things you could do. One is you could make the information available in advance to all the employees about the fact that they can get a reasonable accommodation and who they can contact to request a return accommodation. Alternatively, you can send a notice to employees as they're designated to return to the workplace. You can choose to include the CDC listed medical conditions that are high risk that can inform the employees that they may have that condition and they may need to request an accommodation. Either way, when you get a request for an accommodation, you want to begin the interactive process and deal with each request on a case-by-case basis, and make sure that the people who are designated as the contacts understand how to handle these inquiries, particularly, to the extent that there's requests for accommodation on medical conditions or religious beliefs or pregnancy, which I think are going to be the big hot topic ones for COVID-19. Similarly, if you have a screening protocol for employees every day, what if an employee wants an alternative? Do you have to accommodate that? Well, you have to treat it as any kind of other request for reasonable accommodation. There may be disability or religious reasons that the employee request the accommodation. If it's not obvious, you can ask for information, but the key is you want to treat it like any other request, and it's case-by-case basis. Questions we've gotten a lot in the past webinars is, well, I'm concerned I have an employee who's older. I really don't want to bring them back because they be at higher risk of getting an infection, and I just, one, I don't want to put their health at risk, and two, I'm worried about the liability. Can you exclude that employee from the workplace? The EEOC says, as we've advised, no, you can't involuntarily exclude an employee based off their age, even for benevolent reasons. Employees also don't have a right to reasonable accommodation based on age, but older workers may have a medical condition that entitles them to reasonable accommodation. But the employer can't make the decision for the employee based on age. They also had a question about telework, particularly, is there sex discrimination concerns with providing accommodations for workers who have school-age children and maybe need an accommodation? You can provide flexibility so long as it's not based on a protected characteristic. So specifically, female employees can't be given more favorable treatment than male employees based off some assumption about who has caretaking responsibilities for children. I wish my wife would listen to that. She doesn't do 85% of the child care work. It's 50-50, but she'll never agree to that. I hope she doesn't watch. And then, similarly to the question about age, can the employer exclude a worker who is pregnant? And no, even if it's motivated by a benevolent concern, the employer can't discriminate against the employee based off the pregnancy. It's got to be the employee's decision, and you want to do an interactive process on that. And then as a reminder for pregnancy accommodations, there's two federal discrimination laws that are relevant. The ADA doesn't consider pregnancy to be a disability, but there are many pregnancy-related medical conditions that could be disabilities under the ADA. And then under Title VII, a pregnant woman must be treated the same as any other worker on the basis of their ability or inability to work. So you want to consider job modifications like telework, and you want to ensure that supervisors and managers know how to handle pregnancy related inquiries and accommodations.